Mickey, close that door, please.
This meeting in the City of Eureka Springs City Council will come to order. Clerk will establish a quorum.
Lady Balance.
I'm here.
Arthur Raphael.
Here.
Butch Berry.
Present.
Karen Lindblad.
Present.
Ken Poundong.
Here.
James DeVito.
Here.
We have 6.
All right, everybody please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All.
Next will be the approval of the agenda.
Move to approve.
Second.
Second.
Floor is open. Mr. DeRito.
I would like to remove the taxi franchise workshop date from the agenda.
Second.
Be number 4 out on your unfinished business. Next, yes, sir.
I'd like to remove item number 5 from the agenda, discussion of the auditorium agreement. The extension of the contract has already been let for 2013. So there's already a contract in place for 2013.
Well, I'd like to talk about that.
Was there a second?
I'll second.
Okay. Anything else?
Decided again.
Ms. Lindblad.
Yes, I'd like to put that item back on the agenda because I think we need to talk about it.
Second.
Back on. Anybody else? Would y'all have any problems with this? I'm sorry, go ahead.
Mick, go ahead. I think we're going to do the same thing.
Moving the municipal league attorney up to first of unfinished business, or you want to do him now?
So moved.
Or after we do public comments? Do him before unfinished business?
So 6 and 7?
6 and 7. Second.
Yeah, 6 and 7. Anybody else? Nothing else? Any further discussion? All in favor of the amended agenda, say aye.
Aye.
Any opposed? Okay. Next will be approval of the minutes for 2 dates. The first will be October the 8th, 2012.
Move to approve.
Second.
Made and seconded. Any additions, deletions, corrections on October the 8th? If not, all in favor say aye.
Aye.
Any opposed? Like sign. Okay. Second will be the minutes for October the 16th, 2012.
Move to approve.
Second.
Second.
Changes, deletions, corrections.
Correct the date and what you just stated, please.
I'm sorry, I didn't hear your question.
Correct the date of what you just stated we're approving.
I thought I said October the 16th.
You said October the 12th.
Is that not correct? Okay. Any discussions? All in favor say aye.
Aye.
Any opposed?
Abstain.
Next will be commission, committee, authority reports, expired terms. Planning, Beverly?
Thank you. The Planning Commission would like to have discussion for outdoor sales added to the next agenda. This is what you read in the paper, Mr. Ponnell. But we gave everyone a packet about this in their boxes. It has ordinance 1020 in it, which was written in 1977. And then the next ordinance that was written in 1999 that amended it, and our recommendations for that. If you could just add that to the next agenda for discussion. Also, tomorrow night, the BOZA and Planning Commission have a public hearing for a setback variance at 24 Pine Street. We're going to be meeting in the mayor's office, and we're not actually going to be live, but that will go on as scheduled. And we are beginning to work on timeshares. That's it.
Thank you. I don't have anything under CAPC. We do need to keep Mr. Maloney's family in our thoughts. Apparently his mother is extremely ill, and we don't know what the status of it is right now, so everything about Mike. Hospital Commission, don't have any reports. Today you vote on the nomination of Myrna Thaxton for Parks. Yes, ma'am.
I haven't been able to get a hold of her, so I'm not voting on her until I can get a hold of her.
See you.
Likewise.
Okay. Is that a motion to postpone the vote
Make a motion, excuse me, to postpone the vote.
to the next meeting? Okay. All in favor, say aye.
Aye.
Any opposed?
No.
Kind of, what did you get, 501?
Yes,
Right.
I'll call it, sorry, 501.
HDC, nothing. Cemetery, nothing. Public comment. We have a board.
Excuse me.
Yes, sir.
I voted no.
Did you not?
Yeah, it'd be 5-1, wouldn't it?
510.
It is 5-1.
She said 501.
Thanks for keeping
Okay.
me on my toes.
First on the list is Mr. J. Fusaro. I hope I said that right. Anticipate him being the taller gentleman than that.
You did say that right.
Outstanding. Thank you.
So good for you.
Welcome, sir.
Thank you.
Please state your name.
Hi, my name is Jay Fusaro, and we live at 21 Owen Street. And I just wanted to voice my support for the police chief and the mayor regarding the funding for police officers. And I absolutely oppose any reduction in the amount of police officers or the funding for those officers. My wife and I came here a year ago as tourists, as guests, and in reading the crime blotter, we felt that it was a very safe place to be. We're from Dallas, and we know what it's like to have your home broken into, to have to lock your doors all the time, lock your car, and at times just generally feel unsafe. And in EUREKA, we felt very safe, and if we lose the ability for people to be able to walk from downtown at 11, 12 o'clock at night up to the hotel, the Crescent, or any other hotel, and if people don't feel safe, we're going to have much larger problems than trying to fund a $30,000 or $40,000 police officer. So I just ask you to continue to support the police and not entertain any reduction in funding. Being a longtime resident in the town, which I'm sure some of you are, is a great thing, but my concern is that it also brings a sense of complacency to the safety of the town. So please don't take that for granted. All right, thank you.
Thanks, sir. Next will be Mickey Schneider. Go, Mickey.
Hi, Mickey Schneider, Assistant for the Veterans Parade. Just doing a follow-up. We have gotten several food donations for the meet and greet on Saturday after the parade. We could still use any and all kinds of sandwiches, desserts, bottled water, chips, any and all finger food. We have our pickles covered, thank you, no more pickles. The cook-off on Friday is for all the restaurants, for any local individual people, for the mayor and the police chief and the fire chief. And the trophy is like this big with this gigantic hamburger on top. Oh my God, it's awesome. And that will go to the restaurant that is considered number one. We need grill people to volunteer to come and do this. All monies go to the Legion. the Post, because they do an awful lot of work free of charge and have no income coming in. And this is to support them, and they support all of us. So you can contact them. There's articles in the paper. Sue has her posters and whatnot out. So please, go ahead and sign up. It's only going to take 2 hours. Be there with your grill at 10:30. Competition starts, and the locals get to join in, and they are the ones who are going to sample and vote. And that'll be 11:30 to 12:30, and then the winners will be announced. So 2 hours, that's it. I'm sure you can send one person. Anyway, so that'll be on that Friday. And, of course, then the parade kicks off at 10. If you're a veteran or a loved one of a veteran or anything like that, or want to be part of the parade, meet at the library area about 9 a.m. Excuse me. Parade kicks off at 10. It will hopefully be done around 11 or so, and then we go straight over to the auditorium, to the gym, and we do our meet and greet for hours. Art show on Sunday. Okay, just a real quick history of Veterans Day that I did not realize I had to do, and it's been called to my attention that I do. Way back in 1919, the first ever Armistice Day was the one that was started in regards to the veterans of World War I. This became a legal holiday for World War I over the years, all the ensuing years. Every president would, acknowledge it. When Eisenhower was in office, he not only made it a legal national holiday in 1947, but he made it representing all veterans of all wars. Armistice Day, which is now our Veterans Day, has always been the 11th day of the 11th month during the 11th minute of the 11th hour. 11/11/11/11. Always. It became a federal legal holiday in 1954. 11/11/11/11. So no, Karen, we cannot have our parade at 2 p.m. This is a leap year. The 11th is on a Sunday. We will not change our 21 gun salute to a Saturday to make it good for the people. The parade is Saturday. We're not changing the time because every year it will be at 10 a.m.
Time's up.
Gun salute is at 11:11. Thank you.
Thank you, ma'am. Sam Kirk. Sam Kirk. Hello, Sam Kirk. Go.
Hello, I'm Sam Kirk on behalf of the Eureka Springs School District, a member of the school board, and we also have our superintendent, Curtis Turner, here as well. And thank you, Mayor, council persons, guests. We have a safety concern about Lake Lucerne Road and the increased traffic flow that we anticipate when we open our new high school. And I believe it creates an immediate and significant safety concern to the children of our community. We also have safety concerns along Greenwood Hollow itself, but our immediate concern is regarding Lake Lucerne Road. First, as the buses come from our transportation area and they're making that turn from Greenwood Hollow onto Lake Lucerne Road, there's a fire hydrant there that doesn't allow for the complete turning radius of buses. Additionally, Lake Lucerne Road is 17 feet wide, and the amount of space that we need for two buses to pass each other is 21 feet. The distance from that intersection to the entrance of the high school is 820 feet. And what we'd like to do is we'd like to be able to partner with the city and ask that that fire hydrant be moved, and agree to a solution regarding the width of Lake Lucerne Road. We've attached 2 proposals from Hutchins and Tomlinson Asphalt. Hutchins is currently scheduled to pave our parking lot the first week of November, and we simply need permission to go ahead and commence with that work. We've talked to the Highway Commission, and they're likely going to be assessing the traffic flow along 23, and we've also had conversations with First National Bank of Berryville regarding their property, which is adjacent on Greenwood Hollow. And we've begun looking at alternative sources of funding with groups that are interested in providing safe routes to school. And we're going to continue to work on those issues. But our immediate safety concern on Lake Lucerne Road is simply the inability for two-way traffic to pass in that area. And we simply need the fire hydrant moved and permission to go ahead and do that work. We've enjoyed the partnership that we've had with the city, and we've always been appreciative of the concern for the safety of the students that the city has had. We see the police department there offering safety, and we appreciate that very much.
And we need to wrap it up. You only got 3 minutes.
Okay, very good. Thank you very much.
Thank you, sir.
And I've attached the current budget from the city, and I see that there's $175,000 in the street maintenance, and $74,000 has been spent, which is about 67% spending. And I also see that the current fund balance on the asset side is almost $750,000.
Send your time's up.
Okay, thank you very much, Mayor. We just simply ask that you allow us permission to do the improvements, and we ask that you put us on the agenda for the next meeting so that you can consider reimbursing us for that work with the attached proposals. Thank you again.
Thanks, sir. Curtis, did you need to say? Okay, all right, thank you. All right, next on the agenda, or on the sign-up sheet, is Farrell K. Hey, how are you?
Hi, I'm Farrell Kay, and I'm here to just try to be brief. I'm here to address two things that came up involving bed and breakfasts. Recently, planning brought to the table, I guess, asking to look at the definition bed and breakfast. The idea being that the definition in the ordinances, I guess, or codes, talks about owner being on site versus tourist lodging, which has no owner on site. And I just want to keep you guys focused on the fact that that's the difference. Tourist lodging has no owners. B&B does. Some B&Bs in this town, people live in the basement, in the attic, in an annex, in a cottage next door, to just keep the place monitored. I don't have guests that need the police called on them, but I mean, the idea being that you can keep your guests controlled so the neighborhoods are quiet. The spirit of the definition was having someone on site. Somehow this morphed into redefining bed and breakfast, and suddenly we're talking about what I'm supposed to serve my people for breakfast. Believe me, I've calmed down in 2 weeks. I was a little outraged because you became the breakfast police, right? You have to agree with that. I've stayed at B&Bs where the food was horrible. There was not enough food. There was too much food. There was food that was a pile of sweets that really shouldn't have been defined as food. I've been served a basket where the microwaver instructions were in it. But it was my choice as a guest to stay in these places. B&Bs in this town can be called inns. Some are boutique inns. In other parts of the country, boutique inns can actually be called boutique hotels. Some are mortar courts in town, okay? Some have cottages. Isn't this all misleading, or is it giving just a different variety for what we offer in this town? I'm wondering if you want to take it back to a traditional bed and breakfast, which originally came from Europe in the 80s. This wasn't the 1900s early. where a continental breakfast was a roll, butter, coffee. There was a bathroom down the hall for all the rooms to use on that floor. And sometimes that still happens in this country, but people have the choice. I'm just concerned that we're taking this, thank you, Ms. Balance, for pointing out that this was micromanaging, because what I serve my people is my business and how I market and what I do. I'm concerned, some B&Bs in this town serve dinner. They're not called breakfast, they're called B&B, right? But maybe that should be called bed and dinner. Where are you going to draw the line? Because are you going to tell me now what I put on my beds? Cotton poly, high thread count? I'm wondering if Bobbie Ray's here, because he should be the one who's going to be enforcing this, right, of what I serve. Is he going to get a call that says, yogurt and muffins and some coffee being served at 7 Armstrong? Get a ticket down there. I'm just upset because we work our butts off. Anyone who knows an innkeeper around here knows that they're fully engaged, as is most people in a tourist town during season. I just want to make sure you realize there's a variety of things that can happen in a B&B. We market to our people. They know what we're doing. If they don't know what we're doing, they're not coming back. I'm a member of the Professional Association of Innkeepers. And secondly, that letter came from Jay Karen of Pate, Professional Association of Innkeepers International. He wanted me to give that to you.
Okay.
We're up for 3 minutes? I have that much more.
Okay, go ahead.
Okay. See, now you slowed me down. I'm a member of the Bed and Breakfast Association of Arkansas. They determine what I do. They determine if I'm a member. I do what I do. My people know what it is. My CUP is a business license that says bed and breakfast, just like the commercial zones. I want to preserve the sanctity of my business. Let me take care of my customers, my marketing, my communication, and my advertising. And let me decide how to run my business, okay? Appreciate it. Thanks for the time.
You bet. So that'll be all the public comments. Next to be on the agenda is the Municipal League Attorney. I think it's Mr. Chris Bradley.
See, now we have a Chris Bradley here already.
How you doing, sir?
Hello, everybody.
You can just place your stuff right here, Chris. I don't think it'll melt.
I'm Chris Bradley, and I'm an attorney with the Arkansas Municipal League. And thanks, Mayor, and thanks, Council, and thanks, Tim, for your efforts to get me in front of this group today. The reason I'm here is because in February of 2011, on a cold, snowy, icy day, and with, as you all well know, with hills that go up and hills that go down, a woman had called to complain to the city about a sewer backup where her toilets weren't flushing in her home. Well, the city diligently went out to that location, even with icy roads, and they climbed the hills, and they got the trucks and the equipment into position, and then they took the line from a jetter, and they applied the jetter to the sewage lines. When they did, the force of the water that came out of the jetter worked in such a way that it caused a backflow into the home of Ms. Nellie Clark. Ms. Clark is out there with her friend, I believe it's Ms. Gillette, who helped her clean up the mess afterwards. So did some of the city employees. They went in there as well, and they did a great job trying to mitigate the effects of that backup. What has happened now is that Ms. Clark has retained an attorney, and she has filed suit against the city of Eureka Springs. Now, as would be typical in such a case, we would file a motion to dismiss that case, and I did. I filed a motion saying that the city has tort immunity, and that tort immunity is, you can find it in that blue book over there at Arkansas Code Annotated 21-9-301. And it's a grant of tort immunity so that unless the city has gone out and purchased some type of insurance, then the city enjoys immunity and is not responsible for the loss sustained by Ms. Clark. But the interesting part is this. There's also Arkansas Code Annotated 21-9-303. That law was passed back in the 60s. And it was passed in response to a motor vehicle accident where the motor vehicle accident plaintiff, the person suing because they said they'd been harmed, said that they were harmed by the action of a city vehicle that caused a collision and causing them personal injuries. The city at that time, Little Rock, enjoyed complete tort immunity. Well, the Supreme Court of this state said this is something that should not go on anymore, and they took away sovereign immunity that the cities and towns of Arkansas had had for over 150 years. In response to that, the legislature in 1969 passed those acts that you find in that blue book, 219301 and 219303. 303 was aimed at the type of situation that the Supreme Court found to be inappropriate for Arkansas citizens dealing with Arkansas cities and towns. It provided that Arkansas cities and towns had a responsibility to purchase insurance or to otherwise be self-insured just the same as any other citizen driving a car on the streets of Arkansas. Right now, that's $25,000, $50,000 for a group of people in a car, and $25,000 for property damage. But an interesting thing has happened. It's not the 60s anymore. So in response to the motion we filed saying, this is not a motor vehicle accident. Yes, a motor vehicle was involved to take people and a jetter up to a location where they could put the jetter hose into the sewage lines to help Ms. Clark not have a problem with getting rid of her sewage material. Yes, that was true. But that's not what was intended by Arkansas Code Annotated 219303. Well, a hearing was done right upstairs. Judge Finch, who was standing in for Judge Crow, who's been out for various reasons, he decided, well, it's a close question, but you know, the statute doesn't really say car wreck. It says using a city vehicle. And he decided that it was more appropriate to deny the motion and to let it to go to trial. In fact, he said, it should go to trial instead of letting the Supreme Court rule on it and then telling me to try that case. Well, Arkansas law also allows, in cases of tort immunity, the city to file what's called an interlocutory appeal. And that's saying, no, this is such an important public issue that this needs to go on up to the Supreme Court for a decision. And that's where the case is postured right now. But here's the other side of it. If this case is lost, it affects not only the city of Eureka Springs, it affects every city and town in the state of Arkansas. It also is so extraordinarily broad that we believe that it could affect a fire engine going to put out a fire. There's a vehicle involved, and they don't put out the fire soon enough, or they put out the fire and break something that they shouldn't maybe have otherwise broken. Well, then, is that the kind of case that 219303 now says, city, you have responsibility for these kind of cases? So that's why this is a very important issue. Now, before I got the case, we had heard at the Municipal League, another attorney, Mike Mosley, and myself, had heard that there was some sentiment here in Eureka Springs that perhaps the city might have, well, perhaps they should help Ms. Clark out. After all, it was the city employees who put that jetter in, the sewage lines, and it's them who turned on the water, it's them who put on the force to clear that line. And Ms. Clark's friend, Becky, I think it's Ms. Gillette here, will tell anybody who will listen about what a mess it was to clean up. Ms. Clark will say that due to the cold and the situation on the roads, that she couldn't get out of the house. She had to stay there in a very unpleasant environment. So the idea was thought to come to the city council to see if the city council had an interest in avoiding what the Supreme Court might do and avoiding what a judge might do if it gets sent back for a trial, to say, we, the city council, find it appropriate to stand in the gap here and to help Ms. Nellie Clark out by trying to settle this case with her that way, rather than relying upon a program that was set up to protect people who were hurt by police cars driving perhaps too fast, or sanitation trucks backing up into somebody or tearing up a fence or something. Because it's such a totally different kind of case. And there's a lot of sentiment, as I understand it, for somebody who is in Ms. Clark's situation. But we bring it to you because you know your city, you know your citizens, you know this county, and it's not our decision to make on that one. That's something that we believe should be brought to your attention for y'all to take a look at. So that's what we have. Yes, ma'am.
So are you saying that the municipal leagues stand on cases where people do get hit by police cars, where they're, like the case with Nellie Clark? We have another incident that happened in town where someone tripped in the dark over a extension cord and smashed her face in and is getting no remuneration, that citizens shouldn't get anything for things that are done to them by the public, entities that they pay tax money for?
Well, I think I heard three questions there. One is the Nellie Clark type of case, and that's that unique situation. And then the second one is the police car who hits somebody. Under Arkansas law right now, the police car who hits somebody is like if you or I hit somebody. If we hit somebody, then we have responsibility. The city has responsibility up to the limits that are required by the financial safety responsibility law. The case with the cord, the city enjoys complete immunity. So if, for example, somebody should slip while coming up those steps to this meeting, then they are immune under Arkansas law. But one last point, 21-9-302, also in that book, allows cities, if they wish to go ahead and make settlements and make recompense to people who, as you pointed out, might have tripped over that cord that was negligently left out.
Excuse me.
So it allows local decision making. Yes, ma'am.
Well, I failed to mention that was put there by a city employee.
It doesn't make any difference. It still falls right now under the current state of the law. It falls under 21-9-301, that total granatory immunity. 303 is what was done to deal with the Supreme Court's response back in the 60s, and it focused on motor vehicle accidents. Now, here in 2011 is when this happened, it's been kind of changed around. So if a vehicle is remotely involved, well, then the city has to be responsible. State takes it out of their hands rather than under 302, where city council can make that decision. I'm going to get the gentleman in the back.
So we have three choices. We can go to court, we can settle, or allow it to go to the Supreme Court.
Yes, sir. Right now, if you decide not to settle using the city revenues, it can go to the Supreme Court. The Supreme Court may say, Mr. Bradley, you and the city of Eureka Springs are right, the case is dismissed. Or they may send it back to the court to try it. If they send it back to the local court here to try it, well, the law is already made, and then it's just a question of how much should be paid to Ms. Clark. Let me jump over here to go around. Yes, ma'am.
So, if I'm hearing you correctly, the Supreme Court might say that you and the city of Eureka Springs were correct, and we can go around filling people's houses with feces accidentally. Or, on the other hand, the Supreme Courts may say, well, it's ridiculous for cities to be able to go around and deface people's property to pump feces, sewerage into them, that it's wrong for the city to cause adverse actions on people, and they should indeed be responsible for taking care of those.
I would say it a bit differently, but yes. A or B.
A or B. Okay.
Yes, ma'am.
I don't know. The way I understood it, but I didn't really check it out completely, is that don't we have insurance with the Municipal League?
The city participates in a self-insurance type of program. The city has not gone out and purchased insurance from some insurance company in Tennessee or in Missouri. It's a self-insured program, and yes, and the position of the program right now has been to take this up to the Supreme Court because it affects so many cities and so many towns and is so contrary to what the law has been historically. But given some of the sentiment that's been, and the expressions and the ideas and the philosophy that's also been expressed, that it's wrong for a city to have done that and wrong for a city to hide behind some kind of shield of tort immunity, well, we thought it might be appropriate to see what this council wanted to do.
Well, and I just wanted to add one thing. It was not just unpleasant for Mrs. Clark. It was unhealthy for her because there's another woman in town some years ago that this happened to, and you can't stay in a house where this happens. So it's also unhealthy. It's not just unpleasant.
No objection there. Yes, sir.
Could you clarify what you said at the beginning when you said that the motion was filed by the Municipal League to dismiss?
On behalf of the city, yes, the motion was filed.
The judge said what?
Judge Finch denied the motion.
And that left it at what?
Proceed to trial, gentlemen.
And any action we take can overrule that?
Judge also said, I'd sure like to, and I'm paraphrasing, I'd sure like to see this settled. So.
And also of the three scenarios you gave us, there's a 3 out of 5 chance that we'd end up having to pay anyway, right?
I don't know that I could state the probabilities like that. I can state that there's different results, potential results, but I can't get into probabilities.
Well, you said that the Supreme Court could come back one way or the other, which would be 1 out of 2. We could settle, which is 2 out of 3. And then the other 2 were we take our chance and go to court and...
Yeah, on a superficial level, yes, that's right, but probabilities would go into what kind of jury do you get that day, what kind of court panel do you have ruling on your case, do you make a good presentation? So probabilities is a little beyond my scope, but you said it nicely in that it can go this way or it could end up there or end up by doing it this way.
And if it's decided at this table to settle, what procedures would we be required to follow?
I would tell the court that we're withdrawing our notice, and there's a mechanism for doing that. And then I would advise the judge that the case had been settled, and then payment would be made, a release obtained, and an order of dismissal obtained, signed by the judge. Let me go over here back to you, ma'am. Yes, sir.
Ma'am.
Oh, I'm sorry. I can't see very well.
So if we choose not to settle, and this goes to court, and the court rules against the city of Eureka Springs, then this could have ramifications across the state and perhaps even across the country.
Not the country,
across the state.
Across the
that
state.
Cities would not be immune from making things right when they, even by accident,
well, it would also open the door and the windows for anybody saying, well, there was a vehicle involved, and I think I was wronged, so sue them. Doesn't have to be a case like Ms. Clark's case. It could be a totally frivolous case, something that had to be done, perhaps, because it opens the door and the windows for anybody who can create or state a cause of action. City vehicle, city negligence, I was damaged, therefore I should have recompense.
So the way it stands now, the city can accidentally or accidentally on purpose do damage to anybody's property or anybody at any time, and there's no recourse for anybody. So in other words, if we shut out the possibility for fakers to get something from the city, we also at the same time shut out the possibility for people who truly deserve to have recompense.
Well, not accidentally on purpose. Accidentally, the guys that day did not intend to shoot sewage back.
Understood.
Yeah. So it was negligence at best, and right now, until Judge Finch ruled, I would have thought that the case would have been dismissed. Council could have always said, well, we don't like that kind of situation. We're going to make some kind of payment to her anyway.
Yep, we sure could have.
And that's why we're bringing it to you.
Thank you, sir.
I'm going to come back to you, but yes, sir. And then you.
Back to the discussion
Yes, sir.
of insurance through the municipal league.
Yes, sir.
what does that entail? I mean, in a traditional sense of an insurance policy, there's an accident and you pay out.
It's a self-insurance type of, it's a group to self-insure. It's managed by, actually there's a steering committee, and the cities, based on the loss ratio, pay revenues into the program, and the program investigates and defends where appropriate and pays according to the limits imposed by the Financial Safety Responsibility Act, which is what's referenced by the statute.
So if we were to send this case to the Municipal League...
It's there now.
But your response is to litigate the case.
Oh, yes.
I'm interested in, is there any way that we get past litigation that y'all decide that this achieves the level where there should be recompense in this situation in a traditional insurance manner? Does it always have to go to court?
I have no authority to bind the program to that kind of an arrangement. I know that the law is set up that cities can make that choice for themselves. Perhaps if the city were to petition the steering committee, something might be done on that in that regard. But I've got no authority to go that one direction.
So we don't know if the policy that we have would pay off in this situation.
If the Supreme Court says you go to trial and you lose at trial, then the vehicle program will pay up to the limits.
That's $25,000.
That's the $25,000.
Yeah. Nathan, excuse me. Grab a cup for him. Yeah.
Sir, you had a question.
We were interested, and actually at the time they went into litigation, we were willing to do a settlement. Now, who negotiates the settlement if we decide to proceed in that manner?
I could do that at the Municipal League, or imagine Mr. Weaver would be happy to join in. If it's Mr. Parker, he's the one who has the lawsuit going, so he's a focal point for the person who needs to be talked to and dealt with. But I would suggest that you get one lead person. If the council wanted to do it themselves, perhaps one lead person to be communicating directly with Mr. Parker. But if you want, I certainly will, and along with Mike Mosley, if Tim Weaver, or you want Mr. Weaver, your city attorney, to be involved, then that's fine too. And then if you all prefer to do something yourselves, I have no objection to that. I do have a certain time limit with perfecting that appeal, though. And so that's something that I've got a clock ticking in my background that I've got to be careful of.
How much time?
I believe it's 90 days, but I want to look to be sure. So, yes, ma'am.
Okay, well, a lot of my questions just got answered, but I'm just curious what criteria the Municipal League uses to decide if they're going to pay out on something or if they're not going to pay out on something, since that's where we're insured.
This is an odd case. I've been there for over 25 years. I've never seen this kind of a case come along for the vehicle program. It's the first lawsuit of its sort. So that's why it's unique, and that's why I'm here talking to you. Most of the time, I certainly do not go to city council meetings to discuss vehicle cases. We just do our regular work like you would be done in your case if you had that motor vehicle accident. Pretty routine. This is a strange case.
Is it unique because of what happened, or is it unique because it could change the definition of the state statute?
Both. Both. So, I understand that in some other states they may have a different pattern of laws set up to deal with sewer backups. I think the city of Little Rock recently sent me something in the mail, that's where I live, about paying into some program that will help if I have broken pipes. So a number of cities across the country do things in different ways. But this case here set up this way is unique. So.
Anybody else?
Okay.
Ms. Bounce?
It was interesting to receive this information, and in view of the major ramifications that may occur depending on which trail we choose choose to proceed upon, I would move to postpone this issue until next week, or until the next meeting.
Second.
So we've had time to think about it and consider our options, and consider the largeness of the whole issue.
Motion made and seconded to postpone to next week. Any further discussion? All in favor, say aye.
Aye.
Until next meeting, please.
Yes, next meeting, I'm sorry.
Aye.
Any opposed? Okay, it's postponed to the next meeting.
6-0.
Okay, then there's one other issue that I believe the council would like to address with you, sir. Mr. Pownell, would you make a motion to
Motion to discuss.
the second? All right, the floor is open.
It's one of those issues that nobody likes to talk about, therefore there's not a whole lot of guidance written down. What would, if there was in fact under the definition of misfeasance, malfeasance, whatever you want to call it, somebody's not doing their job, enforcing the code, whatever the case might be, what is the normal procedure? I've been asked this question several times, and I've even had the question myself, do the people go to the council and then to the city attorney, then to the municipal? What is the guidelines, or are there any guidelines as far as filing a misfeasance, malfeasance, nonfeasance charge against an individual? And this goes back, we even had accusations thrown at the table several years ago. So I'd just like to know what the Municipal League procedure is, or what the take is from the legal side of.
Right. I'll do my best to answer that question. First of all, there are distinctions between nonfeasance, misfeasance, and malfeasance, with malfeasance being the worst, of course. Nonfeasance is like sitting on your hands and not doing anything, and misfeasance is the smaller, petty types of errors. Then it also depends on whether you're talking about a city council member not doing their job, or perhaps a department head not doing their job, or an employee not doing their job. So depending on who's not doing something, that's going to make a difference there. I remember being told several years ago by a fellow named Bill Fleming, who had been with the league since its beginning days back in the 1930s, that the only time he knew of for a malfeasance case was when a young hotshot who had returned from World War II had got elected to prosecutor in Hot Springs, Garland County, and that was Sid McMath. That was the only case that Bill Fleming knew about where a malfeasance type of case was done with the prosecutor. Another league attorney, a fellow named David White, who is a longtime city attorney at Hot Springs, said there's a lot of problems with that with the idea of nonfeasance, malfeasance, because of the political nature of it and the use of a prosecuting attorney. Third, you get into whether the prosecuting attorney finds something to be worth his or her time to do, given the nature of the other work that they have before them, such as the murder cases, the rape cases, and all that kind of thing. It seems, in my view, recently, that the people at the legislative audit will get you if you mess it up. You might have seen some of the news going on with Gould. You might have seen some of the news going on over there in Phillips County. That's where a lot of this starts, and if the legislature, through legislative audit, refers something to a prosecutor, I could be fairly well certain that something serious is going to happen with that. So that's one of you going to the prosecutor. I don't know how effective that's going to be, especially if it's somebody who maybe they're not attending meetings as often as the rest of you would like. And speaking somewhat cold to the topic, here in this context with this group, that's my first response.
So the avenue is to the county prosecuting attorney?
Yes, sir.
Unless there's been something brought up by the legislative audit committee.
Right. So if it's involving funds and such. Now, there was the case in Gould, you might recall that I think it was the council appointed a person to serve as the clerk treasurer, or at least the recorder of the council, and then the mayor physically got in that person's way as they tried to get into the building to do their work. What happened on that case is the woman filed suit or made a complaint for the physical assault or battery, and they're dealing with the court system to resolve that. So it's not some kind of punishment system for the council to do to impose upon their membership is for the judiciary to resolve. One way to get it before the judiciary in the criminal context is the prosecutor, and another way is through civil by filing a lawsuit. For example, let's say a person is slandering another. Well, they can file a lawsuit if you want. And then another way is through the legislative audit. So it's really going to depend on what it is and what's going on. So.
Thank you. Anybody else? Ms. Bell?
All right. Might I be excused at this point?
I've got one more here.
Oh, one more, okay.
This would regard check signatories, checking account signatories.
Yes.
To be specific, Eureka Springs ordered last year that we would have 4 signatories, to wit, the mayor, the city clerk, the mayor pro tem, and in cases of extreme emergency, the finance director. Now, if the city clerk refused to sign a check because she wasn't sure if there were funds allocated for that, and the mayor pro tem was not available to sign such a check, the mayor had signed it. If an employee in the finance department chose to sign that check, would that be misfeasance or malfeasance? or if the bank let that go through, would that be bank fraud?
I don't know that it would be bank fraud. I'm not familiar enough with banking law in Arkansas to make a conclusory statement that it would in fact be bank fraud. But I would think that and not practicing in this area, but I would think that an employee who signed his name where he's not authorized to do that, for lack of better terminology, would be in big trouble. And I don't know the criminal charges against that. And the fraud, I would think that a person could be terminated for acting in excess of their authority. But I can't tell you all the fine points.
So who would one approach to bring this issue up and research it and find out what should happen?
Well, if it's an employee subject to a department head, I would think it's the prerogative of the department head to go ahead and terminate. It may be that the city council has a grievance procedure for that person then to bring a grievance to the council to override that. It may be that the person could appeal to the mayor. So there's a number of different methods that you have in place for somebody who is an employee.
Well, what if that department head and the mayor and the city attorney all say, oh, it's okay, we don't care what you said, it's okay, this person's going to sign this check and it's okay. Then what are we supposed to do?
Sounds like there's something I don't know, because there's some reason for that to be said, I hope, rather than, I'm sorry, you just have to do things my way. I like to believe that people have reasons behind their actions, and so there is something I'm missing here I don't understand.
Well, then I'll bring it to the fore. It's my understanding that a member of the finance department...
Point of order.
State your point of order, sir.
We're only going to get one viewpoint here. This is not the place to discuss this item. This is not a court of law. We're not trying an employee here. I take objection to the way this is developing.
I'm trying to get some information that may be pertinent.
Maybe you should talk to the county prosecutor then.
Anything further from Mr. Bradley?
I will support what he said. If you feel that strongly about it, talk to the county prosecutor. If you can't get...
Okay, and what would be the next step beyond that person?
Well, I don't know.
You don't know?
I don't prosecute. I don't do criminal practice. If you're not getting traction with the council and the prosecutor doesn't want to do it, I call legislative audit, perhaps. Get somebody who's in the newspaper, wants to write a story, perhaps. But I really can't advise closely on something like that.
Thank you very kindly.
So I'm sorry, but I can't.
Any further from Mr. Bradley? Last chance. Thank you, sir.
All right, thank you, Mayor.
Thank you very much. You're right. Okay. With that moves us on to number 1, unfinished business. I believe it states it's postponed until the side ordinance is approved. Number 2, building permits, parking lots ordinance 2161 will be the second reading. Motion to discuss.
So moved.
Second.
The floor is open for discussion. Mr. Barry.
I still feel that item under number 1, where it reads, it's about the second sentence from the bottom of item 1 of section 2, where it states the commission shall review the application for appropriateness under Eureka Springs City Municipal Code and all city building and or construction codes. I think that should be eliminated because of the qualification of the planning commission. This is something that the building inspectors should be doing in reviewing building codes and construction codes.
Mr. Pano?
Move that we suspend the rules and put ordinance 2161 on its second reading by title only.
Second.
Any further discussion? All in favor say aye.
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 Any opposed?
No.
Need a roll call? Okay, sorry. We need a roll call vote, so we'll redo it.
To remove it.
Mr. Pownall?
Yes.
Mr. Berry?
No.
Ms. Balance?
Yes.
Ms. Lindblad?
No.
Mr. DeVito?
Yes.
Mr. Raphael?
Yes.
4 yeses, 2 noes. Ordinance number 2161. An ordinance amending chapters 11 and 13 of the Eureka Springs Municipal Code, setting certain requirements on permits issued in commercial zones.
Move that ordinance 2161 be approved on its second reading.
Second.
Made and seconded. Beverly, you had your hand up for something, son.
This came from the city attorney, but it does seem to me that the words "all city-adopted building and/or construction codes" is a little out of our purview, and that is going to be, the building inspector is going to do that part. So if you wanted to make a motion to remove those words, "all city-adopted building and/or construction code," the planning commission doesn't have a problem with it. City attorney might have an issue, but the planning commission doesn't have a problem with that.
Mr. DeVito?
I'd make a motion to amend ordinance number 2161, striking the words that
There's a motion on the table.
we're in discussion.
There's a motion on the table. You're trying to make a motion,
I'm
right?
trying to amend, but
Motion to amend.
yes.
Yeah. You didn't say that.
To reflect the words from the planning commission chairman.
Is there a second?
Second.
Okay. Any further discussion on it?
Yes, I'd like to know exactly how that would read if that comes to pass.
I'm not sure which words you're referring to.
If I might,
Mr. Berry?
I would suggest that it would read, starting with the fourth line up under item 1, section 2, where it says, "The commission shall review the application for appropriateness under the Eureka Springs Municipal Code and any adopted guidelines of the Eureka Springs Planning Commission," which would eliminate the words "all city adopted building and or construction codes."
So we're in section 1, number 1?
Section 2.
We're in section 2, number 1.
Right here. I believe it's section 2, number 1, last sentence. All city adopted building or construction code. Mr. Weaver?
The reason those words are in there is because basically they're a clarification of what the city code is. City municipal